My Lord,
Mr. Bhandari, that is subject to Constitution and law. So you borrowed this power from the Constitution and subsequently you made rules.
yes, my Lord.
This is the intent.
This is the intent. This is the intent. My Lord, the citation is by Muhammad Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My Lord, this expression, subject to Constitution and law, was discussed in detail by Mr. Justice Cakehouse in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739.
एक सेकंड दूसरा कौन सा है?
2015 SCMR 1739.
ठीक है, ये phrase discussed हुआ. This phrase has been discussed.
This phrase, subject to the Constitution and the law.
कैसे किस नतीजे पे पहुंचे?
And they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the Constitution. See? So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the Constitution.
Relevant page बता दीजिए उसका कौन सा judgment है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले
and Imrana Tivana ID 2015 SCMR 1739, paras 51 to 53 at 1764 1765.
Law Development Authority 41.
इस वाली लॉ की सोर्स पर क्या? Go ahead.
इसकी. So this by itself, I say. So you go back to 142, and there is no other provision in the body of the Constitution dealing with this. So my Lord, you go back to 142. 142 takes you to entry 55. So let us see whether there is any
Entry 55 is only related to the jurisdiction part.
My Lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the Constitution.
My Lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो सब्जेक्ट टू दी कॉन्स्टिट्यूशन है एंड लॉ के ऊपर नहीं है. इसके ऊपर आप जो डेफिनेशन बता रहे हैं,
केकाउट साहब ने स्पेसिफिकली सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ भी डिस्कस किया.
जजमेंट है ना, ये एलडीए का जो जजमेंट है इमरान टिवाना का.
नहीं सर, आप केकाउट वाला देखिए. केकाउट साहब की
द ओनली वर्ड सब्जेक्ट टू द कॉन्स्टिट्यूशन.
नो सर, ये जो 65 सुप्रीम कोर्ट है उसमें दोनों डिस्कस.
इट इज रेफरिंग द आर्टिकल 142. उसमें तो शब्द लफ्ज ही शुरू में इंट्रोडक्शन है,
सब्जेक्ट टू
बताया सब्जेक्ट टू कॉन्स्टिट्यूशन.
जी, बट जो 65 सुप्रीम कोर्ट है उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया.
इसका जो 65 का कौन सा पेज?
623 at 633.
जरा इसको पढ़ लें.
65 अगर आप देखते हैं सर.
Yes.
जी, my lord, at 633.
ये भी सब्जेक्ट टू दिस कॉन्स्टिट्यूशन ही है, लॉ नहीं है इसके अंदर.
है. जी, आप देख लें.
पेज आप बता रहे हैं उसमें तो नहीं मिल रहा.
जी, ये आप यहाँ से
रेफरिंग पेज 633.
ये सर मैं नीचे से 11th 12th line from the bottom.
पढ़िए.
At 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this Constitution and not to this Constitution and the law. A reference to the various provisions.
Then my lord is correct.
My lord, आगे देख लेते हैं. A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. But whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution, the Constitution says so. So, when Constitution and the law.
So what? I'm not following.
Well, what it is saying is.
Don't use your own words. Use the words of the judge.
This is that whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution.
It's not a power that is giving legislative competence.
Yes, that's what I'm saying. That
you have to go back looking for the competence.
Yes, you have to go to the source of the power in the Constitution. And there the source of the power has to be in some other provision of the Constitution, which takes you to 142, and 142 takes you to entry
No, fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I
No, but this.
ठीक है आपने मेहनत की, that's good.
But this is how I read this passage. Well, then let's go to entry
Do you
55.
say that that law under 191 would stand through 55?
It can only stand through 55.
Only through 55?
Only through
Chale.
55. Your
But
lordship has-
एक सेकंड ठहर जाइए.
मालूम.
Why not 55 read with 59?
But these are, 59,
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा what my understanding is, I may be subject to correction. It may not specifically be mentioned there, but it can expand. If otherwise 59 is redundant, so then ancillary matters, incidental or ancillary matters can be added on to. So every provision, every item should be read with 59.
Absolutely.
ठीक है. अच्छा,
Absolutely.
एक second. Incidentally, you mentioned privacy, and I was just going through the list. I don't come across that word in the fourth schedule. Please correct me if I'm wrong.
Well,
You said the Federation can make law, you started with Article 14 and privacy you mentioned.
My lord.
But the cursory examination of the fourth schedule does not throw up the word privacy.
it doesn't, my lord, but there
No,
are,
but you said then both the Federation can make laws.
and it has.
No, it has, can it still be unconstitutional?
Well-
But in the argument, you should forget if it has, this they have also made a law, so that's neither is here nor there. But if the word is not mentioned, then your argument should have been that only the province can make the law.
Well,
Please enlighten me.
my lord, the parliament has, for example,
ये example यही ले लेना.
legislative competence to enact laws about companies. Now, in exercise about companies. Entry 31. My lord,
Bandari sir, no, please don't do
Let
this.
me-
No, don't do
At least
this.
make an argument.
No, you use the word, you chose the word of all the thousands of words circulating in the universe, privacy. You chose Article 14. Either you take back that argument or entrench that argument with some legal argument.
That's what I'm trying to do.
आप कंपनीज पे चले गए.
मैं कंपनी से एग्जांपल आपको समझाऊंगा जी.
Learned counsel,
कंपनी, let me
इसको
answer,
मैं जरा
let me
formulate-
answer this question.
इसको फॉर्मुलेट कर दो. आपने जिस तरह कहा कि कानून बनाने का इख्तियार है आर्टिकल 14 है, रिगार्डलेस ऑफ नॉटविथस्टैंडिंग आर्टिकल 191, say a law is validly and competently made by the legislature. What if that law is in conflict with the rules made by the Supreme Court under Article 191? How will you read subject to law? Will the rules prevail or that law?
I will come to that, but let me answer my Lord the Chief Justice's question. My Lord, in exercise of power granted by entry 31, the company law is there. Now the company law contains elaborate provisions which deal with the question of privacy of businesses, their premises. It deals with when search and seizure can be made, when documents can be.
Take the point.
Similarly, because criminal law is on the concurrent list under entry
You
1,
make the
Article
point about
142.
privacy.
Therefore, province has also made laws which affect the concept of
Bandari
privacy.
Sahab,
Well, privacy alone, privacy can very well be a standalone subject matter of a statute. It is a concept
यही तो
which
पूछ रहे हैं फेडरल और प्रोविंशियल.
both. It can,
Okay,
You
ठीक
made
है.
your
It can
you
be
made
both.
your point. If you
It
could
can-
come back to
it can
the,
be both.
you made your point.
My lord.
We've noted your
My
point.
lord,
If you
I
could come back to entry 55.
Entry 55. Let's read it, my lord. Jurisdiction, and it has two parts. The first part, and my lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court.
आगे चलो.
And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, once Then, as my Lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution.
Yes.
No, just wait a minute.
Well,
Where is 184.3 expressly authorized?
it is not.
It is. 184.3 is in the Constitution.
But there is...
समझिए ना, you're not hearing the point. देखिए, extent as is expressly authorized by or under the Constitution. 184 पार तो हमें दिया हुआ है ना आइन ने, हमें बस खुद से तो नहीं आया ना, दिया हुआ है आइन ने, ठीक है? The enlargement of the jurisdiction of the Supreme Court. Now the question is that 184.3 power that is already given to us. The Constitution could have not given that power to us. It is not an inherent power of the nature as under Section 9 of the Civil Procedure Code. Correct?
My Lord.
It's an extraordinary power which is rarely given in any constitution in the world.
Correct, man.
Correct? So
Correct.
far we are good.
Correct.
So that power was given by the Constitution to us. Now, are they giving an appellate forum therein, enlarging the power or taking away the power?
My Lord, twofold answer. They are taking away the power.
How?
By, and I rely on the judgment.
तो जजमेंट को छोड़िए ना, आप आर्ग्यूमेंट्स दीजिए ना अपने.
मैं आर्ग्यूमेंट्स प्रेसिडेंट की बेस पे दूंगा.
आप अपने हम नो कंटेंशन रोड कर लेंगे आपके.
My Lord, it is a curtailment of power because the concept of finality that attaches to judgments under Article 184(3)
So that's a different
is taken away.
concept. देखिए, for instance, a 3-member bench decides something. Naturally, a 3-member bench cannot undo it. 5-member bench हो गई, whatever, full court हो गया. तो 184(3) की उन्होंने enlarge कर दिया power. ठीक है? I'm trying to wrap my head around the fact that you keep saying that it's taking away the power. The first power was conferred by Parliament through the Constitution. That power is being enlarged. If this power was given to, for instance, the Senate of Pakistan, you will sit in appeal over 184(3) because Supreme Court can't sit in appeal over its own orders. So then maybe, yes, you're absolutely correct. But this power, it has not gone out of this building. It remains within the building. And unless you say 2 minds are always better than 5, that ends the story. So you're saying that more minds would actually be destructive of the 184 inherent power if they think about something, or with the passage of time they may want to revisit things or maybe want to appeal things. I mean, no. One thing is, of course, you can revisit something. ठीक है, वो तो एक अलग बात हो जाती है, वो तो revisit आप करते रहें, फिर वो देखें number of the judges count होगा, ये होगा, वगैरह होगा. बट ये तो एक स्पेसिफिक पावर दिया रहा है. इसमें मुझे समझ नहीं आ रही मेरे पावर या सुप्रीम, मेरे तो पावर्स कम हो रहे हैं, सुप्रीम कोर्ट के पावर्स बढ़ रहे हैं, तो इसमें आप कैसे कह रहे हैं कि कम हो रहे हैं? ये जरा समझाइए मुझे.
My Lord, as I said, I am as a counsel of this court bound by the law that your lordships laid down in precedents.
No, sorry to say, this is, आप मुझे कोई चीज बता दें. You as a council are first and foremost bound by the Constitution of Pakistan and the laws of Pakistan. फिर उसके बाद प्रेसिडेंट आएगा. प्रेसिडेंट आप लोग सब पहले रख देते हैं आइन, और उसको वो बाद में आता है. पहले आएगा आइन, फिर आएगा लॉ, फिर आएगा प्रेसिडेंट. ठीक है? सुप्रीम courts, if they've been making laws, I think that's wrong. Their power is to interpret law. If a law violates some constitutional provision, strike it down. Now, we cannot assume power. I have not taken Supreme Court. I have taken an oath to uphold the Constitution and the law of Pakistan until such time that law, I feel, is violative of a fundamental right, or whatever you want to argue, even the whole scheme of legislative scheme that has been laid out. I'm not bound by precedents. If that was the case, I would not have taken oath even as a judge. If I'm bound by all the precedents of the Supreme Court, even dissent, even if the whole court says, I can still maintain I don't agree, but it will still be binding on me. That's a different thing. 189 says it will still be binding on me, but I can say I disagree. Otherwise, you kill dissent also. Then everybody has to agree to everything else. So don't just, these are important questions. You're just sort of saying that your powers have been taken away. I don't feel they've been taken away.
Before you,
My lord, if I
can
can
you
explain-
if you could explain the entry 55 again, I haven't got it.
My lord.
General उसमें बता दें.
My lord, entry 55 allows, number one, only the enlargement of jurisdiction of the Supreme Court.
जी.
And only where there is express authorization to that effect in the Constitution, by the Constitution or under the Constitution. These are the three
Enlargement,
conditions.
enlargement का क्या मतलब है? How
Madam-
do you understand enlargement?
Enlargement, for me, as a matter of plain English, means something exists and you make it bigger. As, again, my lord, with all...
This is, doesn't it destroy your argument?
My lord, let me articulate.
Correct.
The
Learned
word
counsel-
enlargement,
learned
what
counsel-
enlargement means in the
learned
context
counsel-
of entry
Learned
55,
counsel-
and
learned
what
counsel-
enlargement means in the context of entry 55
learned counsel-
has been interpreted by this honorable court.
Learned counsel, जरा मेरे समझने
मैं-
के लिए, there can be two situations. One, 184(3) ना होता और सिर्फ एक अपील दे दी जाती. Now here, 184(3) jurisdiction already exists. A remedy is being provided. So there's a distinction between these two situations. The jurisdiction already exists.
My lord, I'll come to that.
An appeal is a substantive right. It has to be substantively given by substantive provision in the Act or the Constitution. You cannot by implication or by rules or by subordinate legislation create a right. 184(3) is a jurisdiction in itself, the original jurisdiction.
I
For
think
50
if
years
you
it
can go
has
back,
existed as such. Why do you think even the dictators or even the legislative assemblies which amended the constitution did not legislate on the one hand or amend the constitution on the other, and why has it all of a sudden now been done, under what circumstances?
Yeah, learned counsel is, I think, learned counsel, I think there's a...
Mr. Bhandari, you are in a very unenviable position.
Learned counsel,
I sympathize with you. I sympathize.
I can assure that many of your lordship's questions might be answered, and I can't say will be answered,
Learned
only
counsel,
if I'm allowed to articulate my
learned counsel, I think...
I can assure, my lord, if your lordship will just
सिर्फ इतना,
allow
I
me
think,
to articulate my submissions.
बहुत अच्छा क्वेश्चन इन्होंने रेज किया है. I think that is also to be seen in historical context. There were only two judgments of this court after this constitution was promulgated: Darshan Mercy case and Benazir Bhutto's case. Regrettably, this court, after 2010, departed from both those judgments. And the manner in which 184(3) in many cases was used, that probably is one reason why the parliament, a representative body, wanted or intended to have these remedies.
My lord,
if you can go back to entry 55.
I'll go back to entry
And
55,
Mr.
but just as a brief response to that, my lord, two wrongs don't make a right. If this court was wrong, then the parliament is wrong now, and two wrongs will not make a right. And I'll come back to that. My lord, I'll come back to that. Let me go back to entry 55.
So going back to entry 55, can I be your voice on the bench
My
and
lord,
help you?
I'll be so grateful.
So what
I'll
you're
be
trying
so
to say is, just to support you and so that nobody sort of... So what you're trying to say is that entry 55 says that there has to be express authorization from within the constitution for enlargement of jurisdiction. And one prime example, just as Asha had asked a question, prime example is 185(3), which says specifically that you can enlarge the monetary jurisdiction of the Supreme Court. So that is the express provision mentioned. Isn't that the case?
My lord.
So my question then is that if this is what you're saying that it is purely true, there has to be express provision in the Constitution, even though I don't understand the under the Constitution. But anyway, let's stick to the by the Constitution. And example would be 185, and perhaps there are some other provisions which would give that express.
I'll come to that.
But my problem with this is that when we talk about enhancement of jurisdiction, I see that, but I have a problem with the practice and procedure part. That practice and procedure doesn't really flow out of 55, and that kind of makes the word law then redundant in 191, because that law is not finding any support. Even if we say 191 is not enabling provision, then that law must stand alone, must draw some power from some competence from some source. It's not coming out of 55 because it is purely for enlargement of jurisdiction.
Well, it will come if 55 is rightly invoked. Then practice and procedure will come in through entry 59. That, my Lord the Chief Justice.
But 59 reads that it has to be read along with the substantive part of it, which is enhancement of jurisdiction.
Yes.
So enhancement of jurisdiction is related.
Let me give. There are, to my humble knowledge, there used to be one very clear provision was Zain Wali Constitution dena, regarding enlargement of jurisdiction, and which was actually taken notice of by this court in Baz Mohammad Kakar's case. This was, my Lord, before its repeal, this was Article 247, Clause 7.
इसका आप पेज 970 पे पढ़िए ना जरा, ये पैराग्राफ पढ़ दीजिए, इसमें बहुत सारी चीजें बाज मोहम्मद काकड़ वाले केस के अंदर हैं जी। पेज 970 पे पढ़िए, एज इट हैज बीन पॉइंटेड आउट, इसमें तो इन्होंने सपोर्ट किया है कि जो है जुरिस्डिक्शन को बढ़ाना हो, सप्लीमेंटल करना हो तो कर सकती है पार्लियामेंट।
वो रिपील हो गया ना 247 जो
आप कौन सा
तो हो गया, बट द जजमेंट इज देयर, सुप्रीम कोर्ट का अपना जजमेंट तो है ना, वो रिपील।
पैरा 37 of Baz Mohammad Kakar. If I can just read this out, Article 247, Clause 7. As now it's been,
page.
Well, this is the Constitution itself. This was prior to its repeal.
No, Baz Mohammad Kakar ka page
page 967, Para 37.
Citation.
This is PLT 2012 Supreme Court 923. Para 37 at 967. This is one example of enlargement of jurisdiction of the Supreme Court in terms of Article 247, Clause 7, which read, my Lord, neither the Supreme Court nor a High Court shall exercise any jurisdiction under the Constitution in relation to a tribal area unless Majlis-e-Shura, Parliament by law otherwise provides. And pursuant to this, an act was promulgated in 1973. And this was taken notice of by this Honorable Court in. My Lord, that's one example. The other is, as your Lordship mentioned, Article 185 of the Constitution.
185 3 is very
185 2D and E.
2, 3, Sorry,
D, express authorizations by the Constitution.
D, yes.
185 2D and also E.
नहीं, ये पेज 970 पे सप्लीमेंटल पावर का भी जिक्र है। पेज 970 पे जो पैराग्राफ है ना, वो आप पढ़िए, वो डिटेल में
जी जी,
उसमें ये क्लैरिटी आ जाती है, एज इट हैज बीन पॉइंटेड आउट here and above.
My question is that even for a minute, I mean just something that if you were to leave 55 for a minute, what is really stopping, I mean it's a question of interpretation, what's really stopping us from interpreting 191 to mean that it actually is envisaging a law for practice and procedure. It is the enabling provision. Suppose if we go in that direction, what comes in our way? I mean, that sort of solves a lot of mystery also. It is saying that the Constitution is envisaging that the Constitution could provide for practice and procedure, some law could provide for practice and procedure, and the Supreme Court can its rules provide for procedure. Meaning by, one way of looking at it is, meaning by that the Constitution is saying that, yes, for the purposes of practice and procedure, there could be a law. So 191 could be read as an enabling provision. If that is read as an enabling provision, then it sort of solves.
My Lord, with all due respect, in my opinion, it can't be read as an enabling provision. It is a limitation, and the limitation that it imposes on the Supreme Court's power is not limited to practice and procedure.
No, but
let me just finish. Supposing the Supreme Court rules cannot say that in adjudicating our appeals regarding contractual issues, we will not take into account the contract.
My problem is that suppose there were no rules made by the Supreme Court. So how would we look at 191 then? And then there is a law, the word law is mentioned. Suppose it's total greenfield. There's nothing in the. So then a law could be there to regulate the practice and procedure. If the Supreme Court decides not to make the rules for a minute, then the source could be law itself. To call it limiting would be not.
Could it be provincial law also? The law will
considering that it relates to, I mean, that's another issue with Entry 58, that what does relate to federation mean? So if it relates to federation, perhaps it's a federal law that we're talking about or not? That's another question that I want to ask.
The problem, as I said, there is a structural limitation on the word law in Article 191. You can't read it. Shoresh Kashmiri's case, PLD 69, Supreme Court 14 said, law is very broad. But here you will not include provincial law. You will, in my humble opinion, you will not include ordinances because ordinances are executive acts. If you allow, if I can just finish this, if you allow ordinances and rules which are law to be read into law in Article 191, what happens to 175(3)? Judiciary has to be separate from the executive. How can you allow the executive to make rules for practice and procedure of the Supreme Court? So the law, the word law in 191 has inbuilt limitations. I concede that it will include Act of Parliament, but in certain limited circumstances. Only when Entry 55's conditions are met.
So your answer to the issue is that you would come through 55, you would come up with a law relating to enhancement, which is explicitly provided, and in that law, you could then ancillary provide for practice and procedure.
That's my reading.
That's the only way
to get That's the only way you
But then those provisions would relate to the enlargement part, not anything more than that.
Not anything. And that's why I say it's a very restricted power. My lord, sorry.
In terms of you raised a very interesting way to look at this thing, but I think if we look at law as conferring an enabling jurisdiction, I think one issue with 191 is that we have on the same thing, namely the practice and procedure of the court, we have two law-making powers. One is the Supreme Court. It's a direct grant by the Constitution. And if law is read in an enabling sense, then Parliament also. So this creates a situation where on the same subject matter, if I may use that term, ordinarily the problem arises where on the same subject matter, the division in terms of law-making ability is between federation and the provinces, right? So to take a very simple example, Entry 49 of the taxes on income other than agricultural income, right? So the subject matter is tax on income. And the Constitution splits it into two. Agricultural income goes to the provinces, this goes to the, and we have whole issues of trespass and this, that, and you know all of that. Here the interesting thing is that on the same subject matter, practice and procedure, you have the Constitution is giving a grant to the Supreme Court itself. If law is read as an enabling power in Article 191, then the same power is conferred on a separate branch, the legislative branch. So, in terms of the principle of separation of powers, how do we resolve, how would we resolve a conflict if law over there is to be read as an enabling power? In terms of legislative competence, the division between federation and provinces, we know all of that. But here, how would we draw the distinction? How would we resolve a conflict? So maybe, because speaking for myself, I am not too satisfied with the way you are identifying it with entry number 55. Seems to me that a more natural on your reading would be entry 58. But that would mean that it is not an enabling provision. It doesn't really, it allows them to restrict. Otherwise, the conflict between two separate branches making something that is law on the same subject matter, how would that be resolved?
My Lord, I will address that.
Yeah, I think that's an excellent question. You want to mull it over. We will reconvene after lunch or prayers. ठीक है? तो आप आधे घंटे में वापस आ जाते हैं.
आधे घंटे में ठीक है.
ठीक है. You can mull it over the question before you start. We don't want to cut you short and you start something it doesn't finish.
ठीक सर.
ठीक है.
ठीक है. I am grateful जी. Grateful.
नाज़रीन, प्रैक्टिस एंड प्रोसीजर एक्ट पर सुप्रीम कोर्ट में समाअत जारी है. चीफ जस्टिस काजी फायद ईसा की सरबराही में 15 रुकनी फुल